pushcart there for 8 years or more. In effect, it grandfathered people who had been there for a long time, and therefore it discriminated against the pushcarts that had been there for less than 8 years and favored the veterans. Now, was this law rational? Would it pass the rational basis test? Yes, the court said. First, the court said the objective of this law is to preserve the ambiance or the mood of the historic French Quarter, and that's a legitimate objective. But how is this distinction between the older pushcarts and the newer pushcarts rational in light of that objective? After all, the short-termers were saying, and it seems to make sense, hey, if our pushcart is unsightly, if their pushcart is unsightly, there's no difference in unsightliness. No, the court said, here using all of its imaginative powers, it said that New Orleans might have believed, and I'm not making this up, New Orleans might have believed that those pushcarts that had been there for 8 years or longer had themselves become part of the distinctive charm of the area. And that was enough to make a distinction between the two groups. Now that case illustrates, I think, how easy it is to satisfy rational basis. However, there are some cases where a statute can actually fail the rational basis test. What are these cases? Well, typically they're cases where the court concludes that the only reason the state is treating one group differently than another is outright irrational prejudice against a group. A good example of this is the City of Claiborne versus Claiborne Living Center, involving a group of mentally retarded people who wanted to get a housing permit to have a mentally retarded group home. And they applied for the permit, and they were denied it. And the court examined that denial, because some people were getting these permits, but this group wasn't, and they said that this was unconstitutional, a violation of equal protection. And the court applied rational basis review. Now, it's true that the rational basis review here was what we might call rational basis with bite, because the court did take a little bit closer look at the record instead of just making a presumption of constitutionality, so that made it what we call rational basis with bite. But in looking at the record, the court said, there's no reason that we can discern or that you've identified why you've denied this group permit to these people. And you've given group permits to all sorts of other people. There were group permits, for all sorts of groups, for alcoholics, for fraternities, sororities. We think that the real reason why you haven't given a group permit here has nothing to do with legitimate reasons like congestion or parking or anything like that. The real reason why you've denied the group permit to these people is irrational fear of the mentally retarded. Since all sorts of other groups other than this one were getting these permits, here you single out this group and say no. The court said we can only conclude, based upon the record, is that your actions are based upon irrational prejudice against the mentally retarded as such, and that's illegitimate, that's unconstitutional, even under the lenient rational basis test. So, occasionally, you'll find instances where laws will fail the rational basis test because the court has concluded that the only reason that there's a discrimination against a particular group is because of irrational prejudice. For example, treating out-of-staters differently for no other reason, and I want to underline that, for no other reason than the fact that they are outsiders. If you have something like that, a law can fail even the rational basis test. Now, in view of the principles I've just been talking about, the very recent 1996 case of Romer versus Evans becomes more explicable. In Romer versus Evans, the court 6-3 voted to strike down a voter-initiated state constitutional amendment in Colorado. The amendment prohibited state or local governments from adopting any civil rights laws to protect a single class of persons, namely persons with a homosexual, lesbian, or bisexual orientation. Justice Kennedy, for the majority, said, that this disqualification of a single class of persons from seeking the ordinary protection of the laws, not special protection, ordinary protection, was unprecedented. And because it was unprecedented, and because the reasons offered for this broad disqualification were so unconvincing, for example, the state said, well, we have to do this out of respect for landlords and their rights of free association, out of respect for the religious objections of many, or to conserve the state's resources to fight other civil rights battles. The court said, in light of these lame justifications, the truth is we can only conclude that the amendment was based on animosity and prejudice toward homosexuals. And applying a rational basis test, and it applied a rational basis test, nothing higher because it was dealing with homosexuals, still a rational basis test. Even under the rational basis test, again, if the sole reason for a law is just outright rank prejudice against a group, that's not a legitimate objective, and the court will strike it down as they did in that case. Now, other than cases of outright prejudice, remember, rare is the case that will fail rationality review. Just one last illustration of this. What about that New York City case I mentioned earlier that banned advertising on trucks, but said that if you owned your truck, you could advertise your own business on the side of the truck? Well, there are lots of laws like this that basically state a prohibition but then give exemptions. How do we uphold these laws that give exemptions, treat some groups as not covered by the law? Well, in the New York City case, what the court actually did was in effect just assume that the legislature must have had some rational basis for treating the two groups differently, truck owners and advertisers who didn't own the truck. The court said the legislature must have assumed that somewhere along the way there was some difference in how the advertising would be displayed or something like that. And that was pretty much enough. But there are other ways to uphold exemption statutes that you'll see in the cases. One that you sometimes see is the court saying, well, it's okay for the legislature to try to solve a problem, as it says, a step at a time. You have a problem with traffic? You have a problem with advertisements on trucks? You can ban it all as to everybody, or you could deal with the problem a step at a time. Ban it as to some people, and first ban it as to people who don't own their trucks. Later, if you want to do it more completely, you can do it. It's sufficient that you're trying to solve a problem a step at a time. Now, courts frequently invoke this rationale, but it's unclear, really, how legitimate it is or how far the court's willing to go with it. Because if you carried it to its logical extreme, it would really justify almost any arbitrary classification, because the government could always say, well, we're just doing it a step at a time. But there's another, better, more satisfying way, I think, to uphold exemption statutes. And taking the New York advertising case itself, think about this. What a court might do is say, well, wait a minute. Maybe this law looks irrational. Maybe it's too under-inclusive if the sole purpose of the law is to prevent distraction from advertising. Maybe it shouldn't matter if you own the truck or you don't own the truck. But perhaps the law makes a lot of sense and is rational if you consider that the legislature might have had multiple purposes when it passed the law. Maybe, in addition to banning advertising that would distract drivers, they also had the additional purpose of giving small business owners, those likely to advertise on their own trucks, giving small business owners a break from regulation. And if you look at it that way, then the advertising ban and the exemption that went along with it were perfectly rational. Now, one thing you might ask yourself is why, and one thing your professors might ask you, is why do we have such a deferential rationality review test for ordinary economic and social legislation? Well, one way to think about this is to consider the consequences of an alternative approach if the court were to be more activist instead of hands-off. For example, sometimes you see commentators, and maybe a justice or two, who will say, you know, the court shouldn't go so far as to conjure up any plausible purpose that might justify a law. It should, at a minimum, at least judge the rationality of a law in light of its actual purposes, what the legislature was actually thinking of. Well, what if we did that? What would that kind of an analysis look like? Well, first of all, courts are very hesitant to delve deeply into legislative purposes. They realize how imprecise and hazardous that sort of thing is. What motivates a collective body like a legislature anyway? Each individual in the legislature may have one purpose or many purposes.